Actions within or an affiliation of the workplace present an array of employment situations that can influence the duration of employment relationships. Regarding RSM, three employee termination scenarios are addressed. This will provide RSM's HR department with mediative avenues in alignment with the ERA 2000's object under Section 3, which is to build productive employment relationships through the promotion of good faith in all aspects of the employment environment and the employment relationship. The workplace is often comprised of diverse individuals of varying skill sets and personalities. Such diversity can lead to employment conflicts, which spark heat of the moment behaviors, as seen between factory floor worker Juniper and her supervisor Chloe. This argument propagated into Juniper walking off shift in tears. The issue for RSM is whether we rely on Juniper's walkout as her conveyance of her resignation and how we approach it to either preserve or sever the employment relationship in a fair and reasonable process. When assessing the walkout, the ERA doesn't codify how resignation should be made, for instance orally or by conduct. Rather, an objective test, as highlighted in Mike versus Vermeulen, should be applied to substantially determine and circumstantially determine a resignation was given in a clear and equivocal terms by Juniper. Given the facts, Juniper made no reference to resigning. She did not state, "I quit," or provide any form of notice to RSM of her resignation. Hereby, RSM should not rely on Juniper's walkout as her conveyance of her resignation. Thus, it is advised that RSM attempt to reach out to Juniper post-conclusion of the reasonable 24-hour cooling period, as attributed in Taylor versus Milburn, with the primary goal to emotionally assess how Juniper is feeling. If Juniper is willing and able to communicate, RSM should seek to investigate Juniper's true intentions behind her walkout, allowing her to respond to RSM's doubts regarding her employment under Section 103A, subsection 3C, before determining whether to go forward with a resignation or not.
Moving forward, the workplace is not limited to the firm's walls and can extend to outside activities. This probes whether Jaden reported misconduct outside of work with Zoe as a justifiable dismissible offence. In warranting the ability to dismiss, the conduct must be linked with the employee and potentially hold adverse effects on the employee relationship as highlighted in Smith v Christchurch Press Co Limited 2001. Given the facts, Jaden's behaviour, which occurred due to his collegial connection with Zoe at RSM, pertaining to grabbing Zoe's breast, proclaiming Zoe as a hot, sexy RSM colleague he would like to go to bed with, and sending her photos of his genitals, aligns with Section 1171B, sexual or racial harassment by person other than employer, in complement with Section 108B, 1, 2, and 3, sexual harassment. Ultimately, Jaden's actions were adversarial to the employment relationship with Zoe and the workplace. Zoe experienced sadness at leaving other colleagues in a state of concern, with the workplace undergoing mental and emotional instability. This can potentially hamper further manufacturing efficiencies at RSM. Hereby, given the link and adversarial effects on employment, Jaden's actions can warrant dismissal for sexual harassment. Executing Jaden's dismissal, RSM must ensure it is substantially and procedurally fair. The former pertains to having substantial reasoning for dismissal, affirmed priorly as sexual harassment, with the latter ensuring the proper process is conducted when dismissing the employee. Thus, it is advised that RSM applies Section 103A, test of justification, as follows. Place Jaden on notice, informing him that a complaint has been lodged against him by Zoe regarding alleged sexual harassment, Section 103A, subsection B. Post informing arranging a one-on-one meeting with Jaden, allowing him to address and respond to the complaint within a reasonable time frame, i.e. 48 hours, Section 103A, subsection C. Once a fair and reasonable effort has been made by RSM to evaluate Jaden's response in conjunction with witness and victim interjections, a final investigative decision can be made concerning Jaden's employment, Section 103A, subsection D. Hereby, in accordance with the affirmed substandard and procedural fairness of RSM's dismissal, Jaden can be justifiably dismissed for misconduct outside of work, i.e. sexual harassment.
Firstly, it is essential for RSM to identify the positions, jobs, and their companies that they no longer require, without the individual filling that position to have any bias on the outcome. This additionally means that changing official job titles but staying operationally similar is unjustified, which is outlined in Crider vs Vodafone New Zealand. RSM is able to substantiate these redundancies through their forecasting, validating their financial difficulty. Notably, restructuring a business to increase their commercial efficiency is also legally viable, which was first highlighted in Grace Team Accounting v. Break and confirmed in Gene Hale vs Sun Limited vs Wellington Caretaker. The outcome will be officially adjudicated to confirm that RSM is acting as a fair and reasonable employer, ensuring genuineness on an objective basis for their reasoning, which should be in accordance with Section 103. This also includes the consideration for redeployment, which is also deemed as necessary when acting fair and reasonable, as seen in Tocha Hill Farms vs Davidson. Additionally, there must be procedural fairness compliant with Section 4, which outlines consultation and notice requirements, which encompasses RSM being open-minded, providing fair consideration and relevant information, and consulting with the affected employee, which is seen in Vice Chancellor of Massey University vs Wrigley. It is important to note that RSM is not required to disclose any information on the other employees other than the individual affected, and maintain confidentiality of information of the employment facing redundancy. If RSM fails to oblige with the legal procedures aforementioned, there is a risk of an unjustified redundancy, hence also an unjustified dismissal. This can lead to personal grievance claims against the company, which could be costly to the business's survivability.